Welcome to Environmental Law Explored, a podcast series, the podcast of the American Bar Association section of Environment, Energy, and Resources.
Thank you, folks, for joining us. We're here today for a podcast recording of the ESG era, progress, pushback, and the path ahead. My name is Josh Galperin. I'm a professor of law at the Elizabeth Halb School of Law at Pace University, and I'm also the faculty director of Pace Law School's Sustainable Business Law Hub. I'm going to moderate the discussion, and I'm here today with Lauren Lynham and Morgan Martin. Let me first turn it over to Lauren and then Morgan to introduce themselves.
Hi, everyone. Thank you for joining us. I'm Lauren. I'm a law and master's student at Yale School of the Environment and Pace Law School. I'm also the Year in Review co-vice chair of SEER's ESG and Sustainability Committee and a member of Pace's Sustainable Business Hub. Let's just say 2024 gave us a lot of content to work with for this episode.
Hi, everyone. I'm Morgan. I am a recent graduate of Pace Law School and also was a member of the Sustainable Business Law Hub, I guess now a sub-hub alumni. And it has been a year of both momentum and resistance in the ESG world.
Thank you, Morgan. Thank you, Lauren. So we're going to proceed today in sort of 4 chapters, walking through key U.S. regulatory developments, judicial activity, and international initiatives, as well as some sort of legislative pushback. We'll highlight what matters and a little bit of what might be coming next, although this is definitely about the 2024 year in review, so we'll focus primarily on that. So let's begin with, I guess, Chapter 1, regulatory developments in the United States, starting in particular with the SEC, the Security and Exchange Commission's climate disclosure rules. So SEC adopted these rules in March 2024 during the Biden administration, and then the very next month paused the rules. Now, after facing significant legal challenges and political opposition through the beginning of 2025, the new Securities and Exchange Commission under the Trump administration voted to cease its litigation defense of the rules entirely. Is that right, Lauren?
Yeah, you have that right. So the SEC finalized its long-awaited rule to require registrants to disclose material climate-related risks, including impacts from severe weather events, and it also introduced the integration of certain disclosures into audited financials.
Yeah, exactly. And then weeks later, the SEC issued a voluntary stay pending judicial review by the Eighth Circuit that has created some uncertainty around both timing and compliance obligations, especially for large filers preparing for the 2025 reporting cycles.
And firms generally don't like uncertainty, right? Even if the uncertainty may provide a safe harbor, at least temporarily, as we're seeing here. Really, for now, companies are in a holding pattern, but I guess they'd be wise to continue internal alignment on data collection and risk governance. And I guess that sort of brings us to the next subject, at least within Chapter 1, which is labor. Lauren?
Yeah, so turning to the Department of Labor, its 2022 ESG rule has remained intact for now. It permits fiduciaries to consider ESG factors that are financially relevant to risk and return under the Employee Retirement Income Security Act.
However, legal challenges do still persist. A group of states sued, alleging that the rule exceeded the Department of Labor's authority. In February 2024, the Northern District of Texas reaffirmed the rule's legality, even under the newly recalibrated post-Chevron administrative law standard.
The rules survived, but this case, Utah v. Sioux, is still really important because it's the first major ERISA decision post-Loper-Bright, right? So we're likely to see more litigation leveraging Loper-Bright's implications. Morgan, tell us about the EPA Greenhouse Gas Reduction Fund.
Yes, so in implementation news, the EPA obligated $27 billion under the Greenhouse Gas Reduction Fund in 2024. That's arguably one of the most ambitious climate finance efforts to date.
Yeah, and this was structured across 3 arms. the first being the National Clean Investment Fund, the second being the Clean Communities Investment Accelerator, and third was Solar for All. So each of these three arms carry distinct requirements around emissions reporting, community benefit tracking, and environmental justice alignment.
And I guess the governance challenges here are non-trivial. Grantees will need rigorous carbon accounting, impact verification, and compliance with federal environmental justice EJ standards to the extent they survive. So we expect the EPA to update guidance in 2025 as these programs, or if these programs scale. And I guess we have to wonder what will happen on this front in the Trump administration. All may not go according to the original plan, which I guess brings us to chapter 2 of this discussion, which is legislative pushback and ESG policy. So let's talk about some of these countercurrents that we're seeing more of now, but we also saw some of in 2024 because there were two, I guess we can call them sort of anti-ESG bills that passed in the United States House of Representatives in late 2024, HR 5339 and HR 4790.
Both bills are designed to limit ESG considerations. H.R. 5339 restricts Employee Retirement Income Security Act fiduciaries to pecuniary factors, unless non pecuniary factors can be justified as consistent with participants' financial interests.
And just to be clear, pecuniary factors are defined sufficiently broadly to include ESG considerations that impact financial risk and return. I guess, is that right, Morgan?
Yeah, exactly. So, for example, a company's carbon footprint, which is an environmental factor, can translate into pecuniary impacts. So, reducing energy consumption can lead to lower operational costs, while inadequate carbon management may lead to fines, reputational damage, and ultimately lower stock value.
Okay, so HR 5339 fiduciaries must tie their ESG considerations to financial returns to benefit from the Employee Retirement Income Security Act.
Yes, and HR 4790 goes even further. It amends the Securities Act to limit SEC authority on ESG related disclosures and prohibits the inclusion of certain ESG shareholder proposals and proxy materials.
So the documents sent to shareholders to let them know when and where a shareholders meeting is taking place cannot detail ESG proposal matters to be voted upon at the meeting.
Right, unless the failure to disclose significantly alters the information available to an investor.
Interesting. And of course, these bills did not become law. Neither bill advanced in the Senate, but the political messaging is clear. It signals sustained scrutiny over ESG mandates, both from a legal and an ideological standpoint. And then there's also state level legislative pushback on ESG and perhaps a shifting tide at the sort of social and maybe C-suite level. But we'll leave it here for now and turn to chapter 3, which is judicial developments. Lauren?
Yeah, one of the most significant cases was the Nahaveen F. v. Hawaii Department of Transportation settlement. And in this case, youth plaintiffs alleged that the establishment, operation, and maintenance of Hawaii's state transportation system violated the Hawaii's Constitution public trust doctrine and right to a clean and healthful environment.
In June, the state agreed to pursue systematic decarbonization and net negative transportation emissions by 2045. It is the first commitment from a U.S. state in response to a youth led climate litigation.
And by the way, since we're recording this in June 2025, and I don't know exactly when it will go live, but that's June 2024 we're talking about for that settlement. In any case, this could open the door for similar suits in jurisdictions recognizing environmental rights within their constitutions, like Pennsylvania, New York, maybe Montana. So there's more to come there, perhaps. Morgan, what about greenwashing litigation?
Yeah, so greenwashing litigation has also expanded in scope. Courts are increasingly receptive to challenges against vague or aspirational ESG statements, especially when they intersect with securities law.
Claims under 10B of the Exchange Act and Rule 10b-5 are gaining traction. The key question is often whether a plaintiff can demonstrate reliance in material harm.
So the implication for companies is that they should align ESG marketing with verifiable data. Otherwise, they may risk litigation exposure on both consumer protection and securities fronts. And this is a reason that despite the holding pattern on, say, the SEC climate disclosure rule, companies probably should not start backtracking without caution. Morgan, give us an example here of what firms need to think about then as they're dealing or considering greenwashing issues.
Yeah, of course. So, for example, a fast fashion brand that trumps its clothing line as 100% sustainable or carbon neutral without credible data or third party verification, they may face accusations of greenwashing. But if verifiable data is publicly accessible, then those claims will be defeated before they can be brought.
Great. Thank you. So let's move to chapter 4, state-based developments, and specifically, Lauren, what's happening in California?
California has been taking action to refine existing climate disclosure requirements. SB 219 amended the state's corporate emission disclosure laws. It extends the deadline for the California Air Resource Board, known as CARB, to adopt implementing regulations for SB 253 to July 1st, 2025. So coming up here directly, and introduces more flexibility in the timelines for reporting Scope 3 emissions. SB 219 allows CARB to determine a schedule for when companies must disclose their Scope 3 emissions rather than adhering to a strict 180-day deadline after Scopes 1 and 2.
So, for background, Scope 1 emissions are direct emissions from sources owned or controlled by the company, while Scope 2 emissions are indirect emissions from purchased electricity, steam, heat, and cooling. And Scope 3 emissions encompass all other indirect emissions throughout the company's value chain that are both upstream and downstream.
And so the scope 3 stuff is coming later, but importantly, CARB indicated that it won't penalize companies for incomplete scope 1 or 2 data, at least in the initial report due in 2026, as long as they demonstrate good faith efforts.
Yes, and legal challenges are remaining on SB 219. Plaintiffs have been alleging First Amendment and Dormant Commerce Clause violations, but so far no say has been issued.
And then moving from California to Canada, Canada has also been making developments in the ESG field, particularly focused on the S, social, in ESG.
Yes, so Canada's Modern Slavery Act came into effect in January. It requires entities with significant operations in Canada to disclose supply chain due diligence related to forced and child labor.
Reports must be made publicly available and filed annually. This is seeming to be part of a growing trend towards supply chain transparency as a matter of human rights and regulatory compliance.
And this seems like definitely important progress, but it's probably worth also noting that this law doesn't create new prohibitions on forced or child labor. It is simply requiring transparency. So let me then move to EU's expanding ESG framework. There were a lot of developments in 2024, probably more developments there than anywhere. So let's start with the Corporate Sustainability Reporting Directive, or CSRD. Lauren?
Yeah, CSRD officially came into effect in January 2023. And from January 2024, it applies to EU companies that are already under the non financial reporting directive. So the real shift here is in double materiality. Companies must report not only how sustainability issues impact their financials, but also how their operations affect people and the environment across the value chain.
Right. And that also means reporting isn't confined to what happens inside corporate walls. You need visibility into your suppliers, subsidiaries, and partners because the expectation now is that ESG risk is traceable and reportable.
And then we have something else with sort of a similar name, but the Corporate Sustainability Due Diligence Directive.
Yes, the Corporate Sustainability Due Diligence Directive entered into force in July 2024. And this one is basically about due diligence across global operations with a legal obligation to identify, mitigate, and report adverse human rights and environmental impacts, not just within your own operations, but throughout your value chain.
It targets large companies, so that means those with more than 1,000 employees and at least 450 million euros in EU turnover, regardless of whether they're headquartered in the EU. So non-EU companies are not exempt just because they're based elsewhere.
And then in November 2024, the president of the European Commission suggested consolidating CSRD, which is the reporting directive, with CSDDD, the due diligence directive, and also the EU taxonomy, which I think is meant to sort of standardize the vocabulary of ESG investing. And in that respect, is sort of a transparency requirement in itself. Is that right, Morgan?
Yes, the idea is to streamline overlapping ESG regulations into a single framework, which essentially reduces complexity without diluting the obligations.
Got it. And so finally, in the EU, the revised Ambient Air Quality Directive, the AAQD, what changed there?
This came into force in December 2024, and it updates the 2008 standards. It now aligns 2030 air quality targets with WHO recommendations for 12 pollutants, including particulate matter 2.5, nitrogen dioxide, and sulfur dioxide. It also standardizes data collection and requires public reporting.
So it kind of shows that public access component matters. It's not just a compliance issue, but a tool for accountability across member states. Uniform data means easier cross-border analysis and enforcement. However, the EU has endorsed major revisions to both the CSRD and the CSDDD to help ease regulatory pressure and give businesses more time to comply. So we will see what the future holds for both of them.
Yeah, and overall, the EU's ESG landscape is moving towards mandatory data-backed and cross-jurisdictional accountability, even if there is perhaps a marginal slowing right now. But they're going beyond just box ticking, seeking, it seems like, real change. And if companies aren't already embedding this into governance and reporting, they're probably going to be playing catch up as we move forward. Overall, I guess 2024 sort of reaffirmed that ESG is not a static compliance strategy. It's a rapidly evolving field with regulatory, legal, and financial dimensions. Now we're talking about this in June of 2025, and a lot has changed, and I think there's a lot more uncertainty now. But I think, and I guess this is going to sort of a question for you, Lauren, but I think maybe the attacks we're seeing really are primarily marginal attacks, maybe attacks on the language of ESG. We probably shouldn't expect the entire enterprise to come tumbling down. But what do you think?
I agree with you. I think regardless of the uncertainty that we're facing right now, in the future, looking forward 10, 20 years, ESG professionals should anticipate greater complexity, more integrated enforcement, and growing demands for transparency and data integrity.
Yeah, I also agree. And the smart move now is preparation. So whether the regulatory landscape is paused, progressing, or litigating, the expectations are clear. You need to be accountable, consistent, and ready.
Lauren, Morgan, thank you both. Thanks for all listeners for joining us for this episode, the ESG era, progress, pushback, and the path ahead.
We hope you enjoyed today's episode. To learn more about our section, please visit our website at americanbar.org/enviro. Please check where you found us for future episodes. Thank you for listening.